quite a few days. Uh, yeah, so on behalf of the Office of Interdisciplinary Studies, that is IDEAS, I'd like to welcome you all to today's reading circle session with Dr. Gautam Bhatia. We started the reading circle last semester as part of the office's broader student engagement initiatives. We usually do these on alternate Thursdays where we discuss different kinds of texts which are basically interdisciplinary in nature. We touch on different ideas and themes, so to say. Today's session is the second of the semester. The first one we had was 2 weeks back with Professor Sumit Mahajan, where we discussed, Sumit Mahaskar, where we discussed Bombay textile mills and the relationship between labor and caste over a rather expansive period of, say, 150 years. Today we have Dr. Gautam Bhatia. We'll be discussing his rather recent and very interesting book titled The Indian Constitution, A Conversation with Power. I'm sure we are all very familiar with his works. We've all read his op-eds and his books, but still I'd go forward and give a brief formal introduction. Dr. Bhatia is a Delhi-based advocate, a constitutional law scholar, and an adjunct professor in the Jindal Global Law School. He's the author of various books like The Transformative Constitution and Unsealed Covers. He has been involved in several contemporary constitutional cases, such as the challenge to the abrogation of Article 370, the electoral bonds case, the right to privacy case, and others. His work has been cited by the Indian Supreme Court and by various high courts. He has served as amicus curiae on 2 occasions before the Supreme Court of Kenya. He's also the author of 3 sci-fi novels, The Wall, The Horizon, and The Sentence. For today's session, Dr. Bhatia will sort of discuss the book for, say, roughly 20-25 minutes, and then we open the floor for Q&A, and then we'll invite the participants for their comments, reflections, questions, and so on. So thank you, and thank you for joining us.
Oh, it's working, yeah, thank you. So thank you for inviting me to speak here, and I'll just get straight into it. So the origins of this book lie in both my work as someone who practices constitutional law in Indian courts, and also as someone who thinks and reflects and writes about the Indian Constitution. Specifically, the germ of the idea for this book came about during my work in the constitutional challenge to the abrogation of Article 370, where when I was first engaged on the brief and I took a look at the various legislative moves that had been made to bring about that outcome, it seemed to me that these whatever had been done could not stand constitutional scrutiny, because it was a very clear it seemed to go very clearly against the design and structure of Article 370 itself, which seemed to require a double consent of 2 parties, Jammu and Kashmir, its government, and the Indian government, which had not been done in this case. But the more that I read the legal and constitutional history and previous cases, it became much murkier and much less clear, because there was a sustained interpretation of the Indian courts going back to the 1950s that had systematically interpreted the ambiguities and the gaps in Article 370 in a way so as to dilute the autonomy of the state that appears from a first reading of that article. And in that sense, what was done on the 5th of August 2019 seemed more of a culmination of a set of previous moves than a radical break from what had come before. So then that made me start thinking, what's going on here, and reading across a range of different domains in Indian constitutional law with this idea in mind, what's going on here in terms of how has the court understood what happens when 2 sets of power holders in the constitutional scheme clash. How has the court understood that clash and that conflict? And in fact, how is the constitutional design sought to engage with the inevitable clashes that occur when a constitution establishes multiple centers of power? That was the perspective from which I approached this book. And that's in a certain sense perhaps a somewhat new way of at least looking at the Indian constitution. Because if you look at historically the debates around the nature of the constitution or constitution's character, you broadly you see three stories that exist. One is the famous story of colonial continuity, which is that the Indian constitution essentially, in many ways, is a continuation of the old colonial document, specifically the 35 Government of India Act. And this is something that you can see from the various provisions that find their way from that act into the Indian constitution. Then there is a second theory of transformative constitutionalism that says actually a proper reading of constitutional history and the constitutional text will show you that the constitution's design and purpose is meant to transform both the political relationship between subject and ruler as well as social hierarchies. And then there is a third theory, which is that actually the constitution is a function of a compromise between a number of different interests, and there really is no unifying, theory or character that it has even to start with. But what is, in a certain sense, common to these different approaches is that they tend to focus a lot on the fundamental rights chapter, and by extension, to an extent, that directive principles of state policy. So these debates about the nature and the character of the Indian constitution really are focused on fundamental rights and what rights are there, how do you interpret them, and to what extent the state can restrict them. And I think that perhaps brings a certain limitation to how we understand the constitution. And in other jurisdictions, constitutional scholars have understood that. So there is a very famous Latin American constitutional scholar called Roberto Gagrela, whose work inspires and informs this book. And he talks about these two different parts of the constitution, which is what he calls the organic and the dogmatic. The dogmatic is Bill of Rights, the expressions and articulations of rights, what rights people have. The organic part is what he also calls the engine room, which is essentially how does a constitution create, distribute, channelize, and constrain power. So who has power in the constitutional scheme? Who can wield that power? Upon whom is that power wielded? All these questions are settled, or at least attempted to be settled, in the Constitution's engine room, which is those parts of the Constitution that determine these questions. And one important point that he makes is that there is a relationship between these two parts. So you may have, for example, a very expansive Bill of Rights, a very progressive Bill of Rights, but if you fail to address the question of power and the democratization of power, then essentially your Bill of Rights will fail. And so if you look at Latin American constitutions, which are his specialty, 200 years of Latin American constitutionalism, after the Mexican Revolution of 1917, which was the first to bring in expansive bills of rights into the constitutional scheme, other countries followed suit, and you had expanding bills of rights across the century, socio-economic rights, rights of labor unions, and so on. But at no point or at very few points, was the idea that ultimately a Latin American constitution concentrates power in the president was questioned. That was not questioned. And so you had, on the one hand, expansive bills of rights. On the other, you had all the power focused in the president's hands. And so effectively, to enforce these rights, you depended upon the president's patronage. And why would the president want to do that? If that would take away his power. So in that way, the point that Gagrela makes is that you cannot really expect Bill of Rights to work without also addressing the question of power. So that is the framework within which I approach the Indian Constitution, and that framework, I think, really what it does is it does two things. One is that it focuses a spotlight on many parts of the Constitution that otherwise remain understudied or ignored. So, for example, many of you who study constitutional law may or may not have heard of provision Article 293, Clause 3 of the Constitution, which basically says that no state in the Union can borrow money if they already owe money to the Union of India. So if they're in debt to the Union of India, they can't borrow money without permission of the Union. It so happens that every single Indian state is in debt to the Union of India for a number of reasons that we need not go into here. And what has been happening of late is that often the Union of India, as a condition of lending, requires states to change policy on, say, for example, like electricity, right? So basically, the Union of India uses this constitutional provision to influence economic policy in the states, right? And that is really a very fundamental lever that the Union of India has, which really has a far-reaching effect. So, for example, if a state is compelled to privatize electricity on the condition of then not being allowed to borrow, there is a massive then change in the economy of that state and just the way you can access something as basic as electricity. So these kinds of questions are found scattered all over the constitution, and a power-based approach lets you take into account all these provisions and the way that they really structure power and affect rights in really important and fundamental ways. So that is, and secondly, is the second merit of this approach is that it really lets you see the connections between these different parts of the constitution. So in the preface to this book, I talk about, for example, a number of different things that happened at various points in the last 5 years. Now the point is not to focus on the last 5 years because the book is not about the last 5 years; it's about last 75 years. But for instance, the toppling of state governments at various points, where people defect, MPs defect from or resign from state governments, and therefore those regime changes and a new party comes into power. So that we see happening a lot over the last 5 years. The second thing being, for example, special statutes like the PMLA or the UAPA, and the impossibility of getting bail under those statutes, and that's the question of rights. So, of course, rights do play a part in this analysis. And the third thing being disputes between the Union of India and the states on federal issues. And I say that, and we can discuss this perhaps later on in the Q&A, there is an underlying connection between these very disparate kinds of disputes. So what looks actually very different, so what might be the relationship between the defection of MPs and a money laundering statute? Like, what is the relationship? It doesn't look like something connected on the surface. But when you look at the constitution, the lens of power relations, you actually see that there are deep connections between a lot of this, and those connections reveal themselves through this approach that you take to studying the constitution. So the idea is to really look at the constitution as a whole from the perspective of the way that as a document it creates, distributes, channels, and constrains power. Now, what really two things emerge from a basic study in this regard. One is, of course, and this is something that is not new, that the constitution is a terrain of contestation. So there is a contest between different visions of power within the constitution, and you see this play out across the board. Right? So and when, for example, a court, and in India the Supreme Court mostly, is faced with a question of a constitutional interpretation, often it is asked to pick between two competing visions of power. So that's one thing. The second point is that even though the constitution is a terrain of contestation, both in its design and structure, as well as in the previous 75 years of interpretation by the courts, there is a very clear evidence of what I call a centralizing drift, which is that both in terms of design as well as interpretation, the constitution has been marked by a incremental drift towards a centralized, homogeneous, statist vision of power, as opposed to a more decentralized, distributed, non-statist vision of power. Now, like I said, because the constitution is a terrain of contestation, this is not an inevitable drift, but it is a very clear drift over time. This is not limited to a particular regime or a particular government. In fact, in the history of the constitution, you have at least three centralizing governments: India's first government under Nehru, and then the 70s government under Indira Gandhi, and then the present government. So you have at least three phases of political centralization, but centralization in terms of the constitution's own text and its interpretation outlast specific regimes. And that has been more consistent over time. It's not really been linked to a particular regime or a particular executive, right? you see that happening across 75 years, and part of the purpose of this book is to show how that takes place over 75 years. Now, to simplify and to sort of make ideas clear, I divide up this power analysis into six axes, or six axes around which the power in the Constitution turns. Now, these are not the only six ways to divide up the Constitution. You could have other ways to do that. I just think this is a reasonably clean and persuasive way of doing so. These six axes, in turn, I'll just go over them, and if people are interested, we can discuss specific axes later on. The first is the federal axis, so the relationship between the center and the states. Very simple, very well known, everyone knows about this. And technically, India is a federation. States are meant to be autonomous in their domains. In practice and in design, there is a massive skew of power towards the Union of India at the cost of the states. And I look at how it's played out both in the Constitution's text and in judgments of the courts. The second axis is, if the federal axis is the vertical axis, there is the horizontal axis, or power within the Indian Parliament. That is to say, the relationship in a parliamentary system between the executive and Parliament. And here, in at least four ways, you can see a shift of power from Parliament to the executive. The first is the anti-defection law, which basically squashes any possibility of intra-party dissent by ensuring that any member of the ruling party who votes against the whip is disqualified. So you cannot have intra-party dissent. The second is the fact that, unlike many other constitutional systems, the opposition in the Indian constitutional system has no codified rights. So the opposition's ability to participate in Parliament is dependent upon the will of the executive. So that, again, is another shift of power. The third instance is the non-independence of the Speaker. So the Speaker, as the entity who has control over the House, in many systems, therefore, is required to be independent, or at least there are provisions to ensure independence. In India, the Speaker is the nominee of the ruling party. And then the fourth thing is the upper house, where again, often the upper house is meant to be a check upon the majority party in the lower house. That is again hamstrung in India through various mechanisms. So these four mechanisms in combination ensure that within the Indian parliamentary system, the executive basically has a vast amount of power. And often when you hear the terms like Parliament is dead, or why does Parliament not debate bills? How come that bills are passed in like 5 seconds? A large part of this is caused not because we have bad politicians or politicians have bad character, but there are structural features in the Constitution that really make it pretty much useless for Parliament to act as a body of deliberation. There's no really real point to it. So why would they do it? And the answer again lies in the institutional setup under the constitutional scheme, not in the actions of individual persons or even groups of persons. So that's axis number 2. Number 3 is constitutional pluralism or asymmetric federalism. So the idea here is that in any country as diverse as India, as ethnically, linguistically, religiously, politically, culturally diverse, constitutional arrangements should reflect that diversity. In the Indian system, you have a number of ways in which that happens. For example, the 5th and 6th schedule, which have autonomy of a certain kind for Adivasi areas. You have Article 371, whose subclauses provide different kinds of special provisions for a number of Indian states, from Andhra Pradesh to Mizoram. And of course, the most famous example was the erstwhile Article 370. And here the argument is that the Indian constitutional system has always been deeply uncomfortable with the idea of pluralism. In fact, any kind of special provision or constitutional pluralism, whether it is Article 370 or 371 or even the 5th and 6th schedules, have often been wrung from the center through protest, dissent, and even armed struggle, where often finally many provisions, for example, Nagaland, special provisions were given as a concession to prevent secession and armed struggle. So, but there has been no real commitment to a principle in the Indian constitution towards pluralism. It's always been a political compromise and therefore is very fragile and subject to rollback, as we see in the case of Article 370. So there again you have a drift towards homogeneity and centralization. The fourth axis is what constitutional theory calls fourth branch institutions. So institutions that are not legislature, not executive, and not the courts, but nonetheless play a very important part in the enforcement of rights. Independent bodies that are tasked with overseeing the infrastructure of rights implementation. The most famous example being the Election Commission across countries. Other bodies include human rights commissions, gender commissions, data commissions, information commissions, and so on. Many constitutions, South Africa, Kenya, Colombia, and so on, entrench the independence of these commissions in the constitution because they understand that often these commissions will have to go against the executive. Often there will be complaints brought by people to these commissions that implicate the executive. But the Indian constitution does not do so for reasons we can discuss later on. In fact, even the bodies entrenched in the constitution are subject to executive control, the election commission being the most stark example of that, and there are other bodies as well. So here again, the independence of fourth branch institutions either comes via legislation or by interpretation of courts, and both are much more fragile than constitutional entrenchment. So that's axis number 4. Number 5 is the axis of rights. So here in this book, rights are one of the 6 axes in which we examine the way the constitution delineates power, because of course rights are the mechanisms through which you constrain what or the ways in which the state can exercise power upon the individual. Here, this book and this chapter focuses upon primarily the intersection between constitutional rights and criminal law, because I look at the most primordial power of the state over the human body, to imprison, to torture, and to kill the human body, and the ways in which the constitution tries to or purports to put a stop or to control that exercise of state power. And what we find from a reading of these cases, which again are a little neglected in constitutional scholarship, because while there's a lot of focus upon Articles 14, 19, 21, Article 20, which really is the heart of the way the Constitution protects you against state power in a very physical way, is often really not studied too much. And what you find is that in the history of the court, there has been a consistent reading of the Constitution that basically tries to interpret the constitutional rights in a way that would make the Constitution level down to existing pre-independence criminal law, instead of testing criminal law and leveling it up against the constitutional rights. Right? So you see that being a consistent theme of the courts throughout, which again gives you another instance of centralization of power towards the state by weakening the force of these rights which protect the human body and the human freedom against state encroachment. And the final axis is, well, the people. So of course the Indian constitution begins, like constitutions do, with the ringing phrase, "We the people do adopt, enact, and give to ourselves this constitution." Now what role do the people have beyond the preamble? Well, the answer is not at all, because at no other point in the constitution does the document recognize the people as a collective actor or as having collective agency. Unlike other constitutions where the people often play roles in constitutional amendments of a certain kind, in lawmaking, in executive action, and so on, there is no such space in the Indian constitution for the people. So these are the 6 axes that I look at in the course of the book. Additionally, I talk about 2 axes on which the constitution is silent or in which it doesn't speak, but that silent is eloquent. These being the economic question and the social question. So on both the economic question and the social question, the constitution is very minimalistic. The constitution, other than a few provisions involving forced labor, is silent on the economic system that would exist under this constitutional regime. But in doing so, therefore, it perpetuates status quo, right? So it does not disturb the balance of power that existed when it was framed. In fact, by having enforceable property rights and a very diluted land reform clause, it in fact entrenches many of the economic power relations that existed at the time the Constitution was framed. And on the social question, apart from authorizing the state to undertake reservations, the Constitution again is silent on how it will address the deep and entrenched social hierarchies that existed in Indian society when the Constitution was framed. So both the Constitution silences on the social and economic question, I argue, actually are themselves speaking, but they are basically speaking through silence. And in the penultimate chapter, which is inspired by a book called Yesterday's Tomorrows, I say that this was never inevitable because in the history of Indian constitutionalism, you often have other proposals, other ideas being put forward. There are three historical phases where this is most prominent. One is 1920s, when in many of the princely states in the Indian subcontinent, you had radical experimentation on constitutional arrangements, ideas around recall, around referendums, around participation at the local level and so on, which did not go anywhere, but they were experiments. At independence, you had multiple other constitutional drafts that were proposed by people like M. N. Roy, people like Gandhi's secretary, other such drafts, and drafts which came in from the northeast, from the Nagas and the Mizos, that again suggested other ways of looking at how to arrange power under the constitutional scheme, which did not depend upon this centralized, powerful, aloof state. And the final historical moment was the end of the emergency, where seeing the abuse that could occur through decentralizing provisions, there was a brief debate over rethinking the constitutional scheme. But then the 44th Amendment, which sought to roll back many of Indira Gandhi's more centralizing proposals or changes, was very partial. For example, earlier education was under the state list. Indira Gandhi moves it to the concurrent list, which both parliament and states have the power. Amendment 44 does not move it back. It stays there. So in many ways, actually, that amendment left a lot of Indira Gandhi centralizing movements untouched. So that is, in effect, the way the book progresses. And in the end, I mean, the question that is asked is that given this centralizing drift, and given the way it's been consistent over time and over 75 years with a few exceptions, the question to be asked, which I leave the readers with, is that if ultimately our goal is human liberation or human emancipation and equality, to what extent is that possible to achieve under a constitution whose impulses, both in its design and in its interpretation over time, have been so centralizing? So is it possible or not is the parting question that I think we should all think about very seriously, because often in discourse there is this whole thing of either you sacralize the constitution and say, okay, we must, it's a very precious document and it's almost, given by, godlike figures and therefore we have to protect it. Or of course, there's a full scale, thing of let's remove it. I think that both those approaches are obviously mistakes. I think we have to think more deeply about the way in which this constitution allocates power and to what extent that is consistent with a philosophy or a practice of liberation. So I will stop there and then I'll be happy to have a conversation and discuss the arguments. Thank you.
Thank you, Dr. Gautam. It was really wonderful. We can now open it up for a more interactive thing. Maybe any questions, any remarks, reflections, comments?
Yeah, so if you read the chapter in the book, these cases you mentioned are all discussed. So Premnath called Sampath Kumar, Damnu, and cases. And you are, of course, completely right that the 370 judgment, which, of course, in its own way was very shoddily reasoned and sort of, clearly was insufficiently reasoned, especially in its interpretation of 370 clause 3, where it ignored, certain words because they were inconvenient. But of course, the doctrine is much older. And so I'll summarize the argument I make in the chapter, which is that the what the text of Article 370 was designed to do was to ensure something I call the principle of double consent, which is that it establishes the relationship between two entities, which is Jammu and Kashmir and the Union of India, with the guarantee that if any alteration is to be made to the relationship, then it must have the consent of both parties, and that you entrench in the constitution. You can't change that, right? What the court does in its judgments through the years is that basically it alters the principle of double consent from something that is entrenched in the constitution to something which is basically dependent upon the political equation between the two entities. So the moment that then effectively you, for example, the governor of Jammu and Kashmir, right, becomes the consenting sort of party, and the court upholds that change. It upholds the validity of that change. It basically ensures that it is the political relationship between Jammu and Kashmir and the Union of India that will then determine the relationship and not the constitutional entrenchment of that relationship, which of course then creates a problem because obviously from the time that Nehru imprisons Sheikh Abdullah, that relationship politically is one of hierarchy. It's no longer between equals. And so then that political relationship then becomes, the way in which constitutionally the article is eroded over time, right? So what I argue is that the Supreme Court's interpretation of the article that removes the constitutional protection and makes it subject to the political balance of power basically then is responsible for this happening over time. And what I argue is that, and this is something which comes across very clearly in the judgment of 370 itself, the new one, the latest one, and sort of links the arguments in the book, is that the way that the court views Article 370 is the same as the political class views it, which is that this is a provision that is a stepping stone towards the technical, the word used is the integration of Jammu and Kashmir with the Union of India. Now, the word integration can mean multiple things, right? Integration can either mean existing together on equal terms, which is the original design of the article, or it can mean uniformity, homogeneity. And the Supreme Court of India has always viewed integration to mean homogeneity and uniformity. Therefore, the interpretation of the article across 75 years is governed by the ideology of the Supreme Court that the ultimate goal is to have a uniform relationship between the center and all the states. And then you understand why the judgments are the way they are. So that's why I say that ultimately the Article 370 cases across time are reflective of a distrust that the constitutional scheme as well as both the political class and the court have had with the idea of constitutional pluralism. So they've always been uncomfortable with the idea that different kinds of arrangements could exist within the constitutional framework. So, for example, like in Canada, you have Quebec being autonomous, right? So they've always been uncomfortable with the idea, and that you see in judgments, not just 370, but 371, 6th schedule. It's always trying to narrow down autonomy and make it more uniform than sort of expand autonomy and make it more plural. Yeah. 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 Right. Yeah, so I think and here I think you go back to the early cases, right? So if you look at a case, for example, like which I discussed in the federalism chapter, West Bengal versus Union of India, 1962, which involved the question of whether the Union of India can effectively take over state property, right, for the purpose of mining. What you see is that the Supreme Court has always, apart from few cases and a few parts of times in its history, has always had an institutional belief that that the more centralization there is, the better. Now you can go back to the framing moment to understand why that belief was there. There were many reasons. Nehru wanted, Nehru believed that you have to have centralized power to bring about a developmentalist state. No, you can't have developmentalism without centralization. Patel wanted a certain kind of law and order, and so he thought that centralization is required for ensuring law and order. Ambedkar believed that you can only overcome hierarchies of a caste nature by a centralized power, right? So they all had different reasons for believing centralization, but that's what finally they did. And many of those views come into the court's early decisions. West Bengal is one. The other one is its interstate trade and commerce cases, where the court always, talks about the need to have a sort of, a common market, right? Now, where is this coming from? It's nowhere there in the Constitution, but the court, interprets restrictions on interstate trade and commerce by explicitly saying that the goal is a common market. And if you read Louis Tillon on federalism, she says that again, like one major reason for centralization was the belief that a common market is required to bring about economic development. So I think basically in the first 10, 20 years of the Supreme Court, there is established a very, very sort of strong, almost common sense that when in doubt, centralize, right? So unless you have an explicit, provision that militates against centralization, whether you have a silence and ambiguity, always centralize. So now I think that is consistent over time. Now, why is there an exception that is carved out for the court's own power? There's no depth. There's nothing deep here. It's self-preservation, right? So it's just that simple. You want to preserve your own turf. They do it. There's no deep principle at work over there. Yeah. Yeah.
In the context of this constitutionalism and power, and also its increasing reliance on the executive in informing its decisions. For example, in Article 370, relying on the Solicitor General's word that elections will be conducted in Jammu and Kashmir by a certain timeline instead of actually directly. Yeah. And then also, as far as elevation is also concerned, in the collegium as well, because the constitution is as such quite silent in the current this thing, because the collegium comes from a case law.
Yeah.
So then how does that power come and then interact with the executive's power as well in that context?
Yeah, so on the first question, that's a very interesting question, and I deal with it like briefly in chapter 2, the federalism chapter. Because one thing that, and so I think one aspect of centralization that's actually gone a little unobserved or at least uncommented on over the history is that the Supreme Court has actually stripped power from the High Courts over the years and given it to itself. Indira Gandhi tried to do it explicitly because Indira Gandhi could not control the High Courts. So in the 42nd Amendment, there was the change was that only the Supreme Court could adjudicate constitutional challenges. Now that was removed, and so High Courts can do it. But over the years, the Supreme Court has basically made High Courts toothless. So if there's anything that has political significance, the Supreme Court will transfer it to itself. Anything that again they will stay High Court like proceedings. But when they don't want to touch something, they will let the High Court decide. There is a complete lack of principle over there. But basically, even though formally the Supreme Court's only an appeals court, it's not meant to short circuit, the process. But by virtue of its own aggrandizement of its powers, but also by virtue of the class of elite lawyers who do not wish to go to High Courts but want to go to Supreme Court for a number of reasons that we need not go into because they're quite sordid, and again there's no real principle at work over here. It's it makes it easier for the court then to take power for itself, right? So that's like part one of the answer, which is to say that the Supreme Court itself has, engaged upon a centralizing drift with respect to its own position in the judiciary, and that's, I think, again, it's completely unprincipled. It's completely, there's no sanction for it. It's very unfortunate, but it is what it is. It's the situation we are in now. With respect to the executive in terms of appointments and reliance, I mean, see, as far as the Solicitor General in the 370 goes, again, I mean, look, there's no real, I think there's no, again, you can't answer that question by giving a principal justification. There really is none. Uh, it's much like, where in same-sex marriage case you say, okay, committee will be set up, and it's basically you don't want to really, you don't have the intellectual or the moral courage to completely rule in favor of the state. You don't want to do that because you want to, yeah, for whatever reason you don't have the courage to really do it, go the whole way. So you find a way to rule in the state's favor without explicitly doing so. And it's a cop out, right? So it's basically an act of cowardice. But that's what they do. As far as the collegium goes, yeah. So this is the big problem, and I mean, collegium debates can just go on and on. So I don't want to go on and on about that. But what happens is that now, if you look at the way that appointments processes are structured elsewhere, again, you don't even have to take first world countries like the UK or wherever. You look at the country which is global south, like say Kenya or South Africa, two countries I sort of focus on quite a bit. There is an appointments commission, but more importantly, the entire process is transparent, right? So in Kenya, for example, there'll be an advertisement, right? If you're interested in becoming a judge of the High Court or the Appeals Court or the Supreme Court, you will apply, right? And you will fill a form in, just like everybody else in the country, right? You want a job, apply for it, right? And the qualifications, very specific, experience and all of that. Apply for it. There will be a shortlisting process. There will be an interview. The interview is public, right? So an interview will be asked questions, and journalists can attend those sessions. I remember this very vividly, that in South Africa there was this instance where every candidate for constitutional court judgeship was asked this same question, which one among many questions, which was, if you were to disagree with one judgment of the Constitutional Court, which is it and why? And you explain. So through this, you then get to know about the philosophies and what they stand for, things like that. Now that transparency ensures that you weed out people whose views are completely bonkers and who are completely incompetent, and B, you know what you're getting, right? Then it's very clear what you're getting, so it's transparent. Now, here what the problem is that you have taken power as a collegium in those judgments to a point, but you are completely unwilling to make it transparent because you say, and recently this was said, that it will demoralize people if we make it public. Now that is nonsense, right? Like if you apply for a job and get rejected, who else in this country can say, oh, I got rejected from a job, I'm demoralized, therefore, that must be taken into account. Nobody will take it into account except for, the collegium. So they have resisted making it private, making it transparent. Now the problem that then follows is that there is no way of knowing what the influences are, right? So if you walk in the Supreme Court corridors, everybody will say that there is as we say in Hindi, ek tera ek mera sort of arrangement, that one executive nominee and one judiciary nominee, and then both parties will agree to have one each. Now that is very damaging, right? Because gossip is no way to run an appointment system, and B, then there's a complete lack of any kind of transparency into who really has control over appointments and what the criteria are. So I think that therefore in that way, the collegium system, is very harmful, because what you get is the worst of both worlds. If you had, as in the US, where the president appoints judges, so clear, okay, you win the election, you have the power, right? If you win the election, you can shape the Supreme Court to your own ends. You may hate that, you may like it, but you know what it is, right? You know the way the Supreme Court will rule in a case, because it's Trump's Supreme Court, right? Sometimes it'll surprise you, but often not. Or you have this above board appointments provision, like commissions, where there is no dominating sort of voice. We have the worst of both worlds, where on the surface it's like independent because collegium appoints, but it's so opaque that everyone knows behind the scenes there is influence, but you don't know what it is and how. And that basically gives us essentially, I think, like, yeah, the worst of all worlds, where you have neither transparency nor independence. Yeah.
So I was listening to this lecture by Professor Mohan Gopal where
Yeah.
he's talking about how the source of law recently has been changed by the Supreme Court from being just the Constitution and nothing else to also being other sources of law. And it's not just a recent thing; it's a developing thing through the doctrine of essential religious practices, whether judges are judging or basically deciding on what practices of a specific religion may be considered essential and etc etc, to the point where you come to the Ayodhya judgment, where it is completely based on mythological and somewhat pseudo historical uh, imagery, rather, if even not even facts, as opposed to just looking at the constitution and saying that this cannot be allowed. So how do you then take that into the power that the courts now wield of looking beyond the constitution as well in deciding?
Well, the Constitution is never a self-interpreting document, right? So it's a historically rooted document. It's a political document. You cannot have interpretation of the Constitution without drawing on history, on politics, on culture, and on your views of the way these interact, right? So I think that's always been the case. In fact, you're talking about the ERP test. The ERP test originates in 1954, right? So it's like it's very, very old. And I mean, if you look at early judgments of the Supreme Court, it's inevitable. Like I said, like you are interpreting uh, Part 13, Interstate Trade and Commerce of the Constitution, and you are asked, is this tariff that the state has put on vehicles going on the road using its highways, is that legal or not, right? Now, again, how do you interpret that? The court says, look, the purpose of the Constitution is a single market, therefore, right? So you're drawing on an economic theory, right? So you can't adjudicate without drawing on all of this. The difference, I think, is that in the early years, there was a lot more clarity and transparency of what those theories were, right? So you're clear. You're saying, okay, look, I, the Supreme Court, think that the Constitution was meant to uh, support a common market. Therefore, I say this. Now, I can then say, okay, as a historian, I think you're wrong, and history shows it's not the case. And we can have a debate. The problem now is that this is all untransparent, right? So the assumptions are not ever stated. They're just left unstated. And then how do you engage with so I think that's more the problem. Not that the court looks outside the Constitution, because you have to. Like, as a judge, you have to look outside the constitutions, because those words can't be interpreted in a vacuum. They'll always come with a certain baggage. It's just that you have to give public reason, to justify yourself, which they've stopped doing now. I think that's the bigger problem. Hi. Yeah, I mean, one thing I say in the book is that often we say that, oh, the constitution is great, but we have bad judges, judges who can't stand up, judges who do this and that, and so they wrongly interpret the constitution. And part of the book's purpose is to push back a bit against that. It's a little more complex, because in many of these cases, actually, the constitutional design itself is promoting centralization, right? So, I mean, for example, election commission issue, right? I mean, or even just take for example the ongoing case around the governor's pass, right? Like you all know what's happening. Now, okay, what the Supreme Court has done to use the presidential reference as a backdoor to re-litigate a case is completely unjustified, right? Like it's basically what it does, it gives the Union of India a route of appeal which nobody else has, right? So henceforth, any judgment the union doesn't like, they can appeal via the reference, and that is ridiculous. It's like completely unjustifiable. But that apart, if you look at the original judgment of Justice Pardiwala, right, and if you read that judgment and you read the text of the Constitution, what actually is coming across is that what he's trying to do is he is trying to use judicial interpretation to solve a design problem, right? Because the during independence, right, at that point of time, the states were not states the way they are now. They were provinces. They were British administrative units. The idea that states have their own there are democratic units was not really a thing at that time. In fact, even the framers didn't believe that, because you only had states coming in like that for the first time after linguistic reorganization, right? So in 1948, when the constitution is being framed, you think of states as purely administrative units, right? You have to devolve something. The center can't do everything, right? And so your design reflects that. You think you need governors to keep any kind of, you know, recalcitrance in line and just have the center's man over there, right? And so you create this deeply flawed document where you just leave these big gaps, which can then be used by governors. But again, the text does not solve that problem. And so what? And then you find out 75 years later that now states are fully democratic, like entities, but you have these provisions, and governors can just like stall, a legislation. And so then either you amend the constitution to solve that, but why would you? Because then the center would lose. Whoever is in the center would lose power, right? You want to hold that power. So then the courts have to then do this sort of twisting, pulling, pushing to try and like find a solution. And then again, that then is open to attack as being overreach. So basically, the constitution is centralizing, and if you as the court try and counter that, it's always much more difficult than just going along with it, whether by choice or by conviction. Yeah.
My question is about regards to the federal structure and how there have been these recent judgments where the Supreme Court has been extremely ambiguous or has refused to go into the questions like Article 3, for instance, in
Yeah.
the 370,
Yeah.
or
Yeah.
when it came to the defection issue and actually looking at things and in the Maharashtra case.
Yeah.
So, using ambiguity as a means to sort of then consolidate power to the center, how would that impact the constitutional design of the federal structure moving ahead?
Yeah, so like I said, that's been the court's sort of position across its history. Now, Article 3 again is like an abdication because they refused to rule on it, right? So there was a very clear, like both sides put a very clear argument. One side said Article 3 gives you the power to convert a state to a UT, and one side said it doesn't. Like, now answer the question, yes or no. It's a very simple yes or no question. They refused to do that. And with Maharashtra as well, there was like a refusal to really answer questions around, when that defection, is something, or like when can you prevent the governor from holding that flow test, right? But like I said, so if you go back again to 62, right, the West Bengal case, there the question was that entry 42 of list 3 as it then stood was competence for acquisition or acquisition of property. Now, West Bengal argues that you read this entry as saying acquisition or acquisition of property except for state property, because otherwise what's the point of federalism, right? If like the union can acquire state property, what does federalism even mean, right? And then the court says actually yes, like there is silence here, but look at all these other provisions of the constitution where you have given these far-reaching powers to the center. So clearly, this power also is there because it's a lesser power compared to what you've already given them elsewhere, right? Now, that could be one reading of the Constitution. The other reading could be that wherever the Constitution intends to depart from equal distribution, you have an express allowance of that, right? So you explicitly allow central power to go beyond. Where you don't have that, you interpret in favor of the states, right? So silences go in states' favor. The court chooses the first reading, which is to say that where you have a silence in the Constitution, interpreted as the union having the power it exercises. And then, of course, that means that therefore any constitutional ambiguity or silence ultimately entrenches central power. And you see that in competence cases, in present substance cases, in repugnancy cases. You see it a lot in Schedule 7. That's where this sort of doctrine that ambiguity is to be understood in favor of retaining central power is most starkly visible. So that's been like a consistent position across the board. The one place it wasn't is tax cases. So MPV Sundaramir and other such cases. In fact, the one departure has been in tax, where they say actually, unless an entry of the list categorically gives the union the competence to tax, it doesn't have it. So that's the one departure from that principle.
Thank you, Professor Bhatia, for this wonderful talk. I was just reading this article by Hindustan Times on the review of your book, and it mentioned a concept called constitutional common sense.
Yeah.
So one request on you to expand on this more, if you could. Another that I was just wondering, what if the apex court's constitutional common sense does not resonate with the society's current current sense of what the constitution should be, and it leaves a silence, and rather than interpreting the gaps which was left by statutes or legislations, it leaves a gap and leaves a silence, and it does not interpret it, leaving it for further, then what kind of power dynamics does it really reflect?
So can you give me an example of the second one? I didn't quite understand.
For example, the court has to answer some question, and it just, rather than deciding, it leaves society is not, for example, the same-sex marriage issue, society is not ready for this conversation right now.
Yeah, so on the first, on constitutional common sense, I'll give you an example. So again, from Article 370. Now, in Article 370, there were two constitutions that were at play: the Indian Constitution and the Jammu and Kashmir Constitution. One crucial question in the case was what is the relationship between these two constitutions? Now, the idea of there being a state constitution, which is in its own sphere equivalent to the Union Constitution, is a very, very common feature of federalism across the world. So the US has state constitutions. Many countries have state constitutions. And it is well accepted that where the domain is federal, the federal constitution will prevail. And where the domain is state constitution will prevail. And there is no hierarchy between these two constitutional documents. Now, in the Article 370 case, this argument could not even be argued because it was very clear, and that the court would not even consider the possibility that the Jammu and Kashmir Constitution was equivalent to the Indian Constitution. And it just wasn't up for debate. And so when I say constitutional common sense, I mean that among the practitioners of law, which is to say lawyers, judges, and others who are involved in the practice of law, there exists these unspoken and uninterrogated assumptions of what can and cannot be argued, as a constitutional argument. And much like common sense, it's just encrusted, right? So it's just there, but it informs everything you do, and it only comes to the fore in a moment of crisis like this one. Other scholars have given other words to other phrases. So constitutional culture, Cheryl Saunders in Melbourne, David Kenny in Ireland, constitutional conventions, some people say, constitutional culture, constitutional common sense, and so on. So that's effectively what's happening over there. As far as your question about the court not deciding, there are two things that happen. Like, one is that sometimes there is something called strategic deferral, right? So the court will avoid ruling on an issue because to rule either way would invite a social backlash that would basically lead to chaos and conflict. And so the court judges that now is not the right time. Let there be some sting taken out of the situation, and then in a cooler time we will adjudicate it. That may or may not be legitimate. I think it's very case dependent, and I can understand why sometimes the court may say, okay, by deciding this case, we will either way unleash violence that is just not something which is a good thing, and so we will keep our hands off. So I can understand why you might want to do that in some cases. But the other kind of deferral is basically where you defer, and deferral favors one party, and deferral will favor the stronger party, which is always the Union of India, right? So, for example, when Aadhaar was not adjudicated for like 6 years, it became a fait accompli because it was spread all over the country. And so I think that kind of deferral is obviously unacceptable because you're deciding the case by not deciding the case. You're basically, there is a verdict without reasoning. As far as the question of is society ready for it or not, again, I think this is like a judgment call. Again, I don't think the court should say in its judgment that it's ready or not ready. The court may decline to take up a case, saying that we think that this is not a case where deciding it would really mean that either way there'll be a problem. So I think that perhaps sometimes the court, you can understand a reason for it, because if the court gives a judgment which is unenforceable, right, then there's no real point to it anyway. But again, courts tend to overestimate often that problem, because you may think that when the Supreme Court of the US in Brown versus the Board of Education ordered desegregation of school buses and schools, there was obviously widespread backlash. And in fact, many white people in the Deep South said, we will not let this be implemented. Finally, the president of the country sent in the armed forces, and it had to be done, and it was done, right? So yeah, I mean, I think sometimes you overestimate unimplementability, but again, this is a judgment call. The court, every court makes, wherever it is located.
If there's not any more questions, then we can call it a day. I just take a moment to thank Dr. Gautam for his time, for very graciously accepting our invitation, for this very wonderful and vibrant session, and for a very wonderful book. We also have the small felicitation ritual as a token of appreciation. So yeah. And thank you everyone for coming and joining us.